Assalamualaikum, my name is Nuril Aizrin with metric number 2312188. So today my group will be presenting on the PBL assignment. Cynthia is a university student who is outspoken and actively engaged in social issues, particularly those related to social and economic justice in her country. She learned from a friend that the local authorities plan to demolish any illegal structures built without permission. Additionally, they will prosecute individuals who set up stalls without a license and capture stray dogs in the area. Cynthia believes that the policies, decisions, and actions of the authorities are unfair, unjust, and inhumane. In response, she organizes a meeting with fellow social activists to discuss these issues. Together, they decide to confront the injustice through social media by criticizing the local authorities. They accuse the authorities of practicing discrimination and claim that some officers are racist and exhibit religious bigotry. Furthermore, they plan to conduct a fiery demonstration outside the public authorities' office. Cynthia and her friends believe they are protected by the provisions in Part 2 of the Federal Constitution. Discuss this situation from constitutional law and human rights perspectives. The first issue is whether Cynthia's actions in criticizing the authorities and organizing an online campaign against their policies, particularly accusing them of discrimination, racism, and bigotry, are protected under Article 10, Clause 1E of the Federal Constitution of Malaysia, which guarantees freedom of speech and expression. According to Article 10, Clause 1A of the Federal Constitution, it talks about the freedom of speech and expression. This freedom allows every citizen the right to speak, express, and share opinions. The term speech and expression includes not only words, but also written statements, physical gestures, and even forms of art such as paintings and posters. It is not limited to oral communication alone. One of the relevant cases is Chai Chun Hoon and Ketua Polis Kampar. The plaintiffs were given permission for two speakers to speak between 11 p.m. to 5:30 p.m. Outside this time, they were restricted from speaking. It was held that the restriction was deemed unreasonable. If the speakers comply with the permitted time, there is no need to limit the number of speakers. The second case is Madhavan Nair and Public Prosecutor. In this case, Parliament imposed a rule that a speaker could not touch on issues in Malay language. The accused discussed in Malay language during the speech and was found guilty. The case confirmed that any law restricting freedom of speech must fall within the scope of Article 10, Clause 2. If not, the validity of the law can be challenged. The last case is Public Prosecutor and Chia Bengpo. The issue was about whether certain speech topics could be restricted. This case reinforces the limits of free speech, especially regarding language, politics, and sensitive issues. In applying the rules, in this case, her expression of dissatisfaction toward the local authorities were on demolition of illegal structures, prosecution of unlicensed vendor, capture of stray animals. The local authorities may argue that Cynthia's post accusing them of racism and religious bigotry threaten public order. However, such accusations, although harsh, are still part of public discourse if they are not inciting violence, hatred, or immediate unrest. Mere offensiveness or strong language does not suffice to restrict constitutional rights. Cynthia's plan to expose perceived injustices through digital activism is protected unless it can be proven that her speech incites violence, promotes racial hatred, or poses a clear threat to national security or public order. In Madhavan Nair and Public Prosecutor, restrictions must be enacted by law and not imposed arbitrarily by enforcement authorities. In Cynthia's case, it must be emphasized that their online expression and social critics are legitimate uses of their constitutional rights. It would be unlawful and disproportionate for authorities to suppress or punish this form of peaceful expression without satisfying the strict tests established under Article 10, Clause 2A and judicial precedents. In conclusion, Cynthia and her friends' act of expressing their dissatisfaction with local authorities through social media and discussions is protected under Article 10, Clause 1A of the Federal Constitution. While Parliament may impose laws restricting this right in the interest of security, public order, or morality, such restrictions must be reasonable, proportionate, and not arbitrary. Cynthia's criticism, although controversial, do not breach these limits unless they incite violence or disorder. Therefore, from both a constitutional and human rights standpoint, Cynthia's actions fall within the scope of lawful and protected speech.
Assalamualaikum, my name is Nur Syahidayah binti Susilan with metric number 2310816, and I'll be presenting the second issue, which is whether Cynthia and the fellow social activists are protected under Article 10, Clause 1B of the Federal Constitution, which guarantees the right to assemble peacefully and without arms when they are planning to conduct a fiery demonstration outside the Public Authorities Office. Firstly, the Article 10 Clause 1B guarantees the right to assemble peacefully and without arms. However, it is granted to only citizens, thus the non-citizens of Malaysia do not enjoy this right. There is no specific definition of the word assembly in the Federal Constitution or the Peaceful Assembly Act 2012. However, in the case of public prosecutor against Ismail and others, the court adopted the dictionary meaning of the word, which means an assembly is the gathering of two or more persons. So, in Article 10 Clause 2B, the Constitution permits the Parliament to impose restrictions to control the freedom of assembly on two permissible grounds, which are related to the security of the Federation and also the public order. So, the primary law that governs peaceful assemblies is the Peaceful Assembly Act 2012 that has replaced the Police Act 1967. However, it must first be understood that this act only facilitates peaceful assemblies without arms and not violent protests, riots, and also something similar. So, if there's a protest where the protesters threaten to harm any persons or damage to property, then it is not a peaceful assembly and should be dealt with as a crime under the Penal Code Section 141, which is unlawful assembly. Under the Peaceful Assembly Act 2012, there is no requirement for a police permit, and instead, the organisers of such assembly must first notify the authorities 10 days in advance under Section 9, Subsection 1. So, no notice is required for meetings in designated places or if the assembly is an exempted assembly, such as election campaign, weddings, open house, and etc. So, if in response to a notification, the police do nothing, then under the Section 14, Subsection 2, silence is deemed as consent. Previously, under the Police Act, everything was prohibited unless permitted, but now under the Peaceful Assembly Act 2012, everything is permitted unless prohibited. Regarding the police discretion, the Peaceful Assembly Act does confer the police a wide discretion to impose restrictions and conditions, which is, for example, arrest without a warrant to any person failing to comply with a restriction or condition, or order to the assembly to disperse. For example, if the assembly turns into a riot or if a crime is committed by the member of the assembly, then the police have the power to stop the assembly and disperse the crowd. Furthermore, the Act also prohibits assemblies at certain places, which is it bars any assemblies within 50 meters of prohibited places, which is can be seen in the list of the prohibited places in the first schedule of the Act. For example, are the petrol station, kindergarten and schools, places of worship, and hospitals. However, this Act has one amendment, which is Peaceful Assembly Amendment Act 2019, where in this amendment, it deletes the definition of street protest, thus effectively allowing street protest. The changes were intended to streamline the process of holding peaceful assemblies and to ensure that people can exercise their right to assemble without undue restriction, particularly in relation to street protests, which were previously prohibited, because back then, street protests were absolutely banned where it involved walking in a mass march or rally. And also, because of the amendment, back then, the organizer must give 10 days notice in advance to the police, but now it being reduced to 5 days only. So there are people who say that the Peaceful Assembly Act somehow restrict the freedom of assembly in the sense of Article 10, Clause 2B of the Constitution. However, in the case of public prosecutor against Yunis Waran, anak lelaki Ramaraj, the court held that the Act does not constitute a restriction in the sense of Article 10, Clause 2B of the FC. However, the Act only lays out a set of procedures that must be followed by the organizer in order to guarantee and make it easier for someone to exercise his constitutional right. So, in our scenario, Cynthia and her fellow social activists are planning to conduct a fiery demonstration outside the Public Authorities Office. First, we can see that they are all citizens and the gathering is more than 2 people obviously. Thus, it constitutes an assembly. Then, Cynthia's assembly is without arms, not a violent protest or riots with intention to threaten harm to person or damages to property. It is just a fiery demonstration as they are angry because they claim the authorities are practicing discrimination and racism. However, Cynthia must adhere to the conditions in the Act, where her group must first notify the authorities 5 days in advance, although the police cannot say no before the assembly takes place. So therefore, Cynthia's demonstration can be conducted as now. Everything is permitted unless prohibited. However, the assembly must not turn into a violent riot or suddenly the protesters are committing crimes, because police still have the power to stop the assembly immediately and disperse the crowd. Next, we can see that Cynthias are planning to do the demonstration outside of the public authorities office. So, the place is not listed under the prohibited places under the Schedule 1 of the Act. Thus, it is allowed. Then we can also see that Cynthia's demonstration can be regarded as a street protest, and this is now allowed under the Peaceful Assembly Amendment Act 2019. So in conclusion, Cynthia and her fellow social activists plan to conduct a fiery demonstration outside the Public Authorities Office is protected under Article 10, Clause 1B of the Federal Constitution. However, Cynthia and the activists must be reminded to not turn the demonstration into a violent riot that can possibly harm the people and cause damages to other property. Or the demonstration will be stopped by the police and arrest without warrant can be given to them if they do not comply with the order given.
The third issue is whether Cynthia and her fellow social activists are protected under Article 10, Clause 1C of the Federal Constitution, which guarantees the right to form associations in light of their plans to organize and confront public authority through social media campaigns and public meetings. However, like other freedoms under Article 10, this right is also subject to certain restrictions. Under Article 10 Clause 2C, Parliament may impose restrictions on the freedom of association in the interest of the security of the Federation, the maintenance of public order, and the preservation of morality. In addition, under Article 10 Clause 3, the Parliament is also allowed to pass laws that further restrict this freedom, specifically in relation to labour or employment matters, education, and the governance of professional or trade associations. One of the relevant cases is Siva Rasa Rahsia and Badan Peguam Malaysia. The applicant challenged a provision of the Legal Profession Act that disallowed politicians from becoming members of the Bar Council. Any restriction on Article 10 Clause 1C must be reasonable and consistent with the proportionality principle. The court emphasized that the right to association includes the right to participate actively and meaningfully within an association. Next case is Nordin Saleh and Dewan Undangan Negeri Kelantan. State Assembly cannot enact laws that effectively penalize or restrict a person's right to associate, such as a law preventing a member of parliament from switching political parties. The court held that only Parliament may restrict Article 10 rights, and even then only within the limits set by Article 10 Clause 2 and 10 Clause 3. The last case is Malaysian Bar and Government of Malaysia. In this case, the bar challenged a new requirement mandating 7 years of experience before being eligible for a position on the Bar Council. It was held that the right to manage or lead an association is not protected under Article 10 Clause 1C. This distinction between forming and managing an association was seen as constitutionally acceptable. Applying the case of Siva Rasa Rahsia and Badan Peguam Malaysia, Cynthia and her group not only have the right to form an association, but also the right to participate actively in the pursuit of their shared goals. Criticizing public authorities even harshly does not automatically render their association illegal or their actions outside the constitutional protection, provided it does not threaten public order or security in a significant way. In conclusion, Cynthia and her fellow activists' right to form an association is constitutionally protected under Article 10, Clause 1C of the Federal Constitution. Their actions of organizing a meeting and planning collective advocacy are legitimate exercises of this right. The right to association, particularly in a democratic society, must be upheld to enable citizens to organize, express concerns, and hold power to account.
The fourth issue is whether Article 8.2 of the Federal Constitution, which forbids discrimination, can allow Cynthia to challenge the authorities of practicing discrimination and claim that some officers are racist and exhibit religious bigotry. So in Article 8, it requires the government to provide fair treatment in all aspects. However, it only protects the government sector only. Thus, the private sector, they did not have the protection under this article. Then in Article 8, all persons are also equal before the law and entitled to equal protection of the law. In Article 8, Clause 2, it then prohibits discrimination under 5 grounds, namely religion, race, descent, place of birth, and also gender, under any law, in the employment by a public authority, or in how any law is applied relating to property or any trade, business, profession, vocation, or employment. So then in this Article 8, it does not require that all persons in all circumstances must be treated alike, but a person in one class should be treated on par with another person in the same class, as the Constitution permits to differentiate citizens into various classes, as long as the classification is not based on the 5 prohibited grounds in Article 8, Clause 2. Now we look at one of the case of discrimination, which is Nur Fadila binti Ahmad Saikin and Syed bin Basirun and others. So the facts of this case is the plaintiff was being interviewed with the education officers of the Education Office of the Hulu Langat District to become an untrained teacher. During the interview, she was asked many questions regarding the general knowledge and also as being a teacher. However, there was no question on whether she is pregnant or not. So she was accepted to the position, and during their first meeting, an officer then asked whether anyone is pregnant, and then the plaintiff admitted that she was pregnant at that time. And then suddenly her placement memorandum was withdrawn. The High Court held that the defendant's decision interfered with the plaintiff's right to be employed, which is contrary to Article 8.2, which provides that there shall be no discrimination on the ground of gender in the employment of any office or employment under a public authority. It is declared by the High Court that using pregnancy as a factor in employment is a form of gender discrimination. So, in our scenario, Cynthia and her fellow social activists are accusing the authorities of practicing discrimination and claim that some of the officers are racist and exhibit religious bigotry. Because following the local authorities' plan to demolish any illegal structures built without permission, prosecute the individuals who set up the stalls without license, and also capturing stray dogs in that area. Thus, they want to challenge it under Article 8.2 of the Federal Constitution. However, the act of the local authorities cannot be considered as a form of discrimination, as it does not concern on the issue of unequal treatment based on the 5 prohibited grounds in Article 8.2, which are religion, race, descent, place of birth, and also gender. But rather, the local authorities just carrying out their jobs as according to the law, as the acts were violating the law. That is, illegal structures being built, having stalls without license, and also stray dogs that may affect the public security and also the public health if it does not being prevented. So, it is not an issue on the law being unjust for a certain group based on the 5 prohibited ground. And Cynthia does not have any proof of the some officers being racist and exhibiting religious bigotry. It is most likely that it was just baseless accusation, as she was angry with their acts, and she's in the opinion that the policies, decision, and also the action of the authorities are unfair, unjust, and inhuman. Nonetheless, the local authorities that are a part of the executive are just carrying out their duties as according to the law. So, we can see that this scenario is contrary to the case of Nur Fadila binti Ahmad Saikin, where the court affirmed that pregnancy of a woman being affected in the appointment of any office or employment under a public authority is a type of discrimination under Article 8.2. But in our current scenario, there is no discrimination in any of the 5 prohibited grounds. So in conclusion, Cynthia most likely cannot win if she challenged the public authority for discrimination under Article 8.2 of the Federal Constitution, as the act of the public authorities planning to demolish any illegal structures built without permission, prosecute individuals who set up the stalls without license, and capturing stray dogs in the area does not constitute discrimination. It is merely the duties of the local authorities to do so in safeguarding the public and also upholding the law, as those people had violated the law. Then there was also no evidence of the local authorities being racist, and this is most likely Cynthia's baseless accusation as she was angry with the acts. And that's all for our presentation. Thank you.